That being said, I'll go ahead and I'll get us started. Good afternoon, everyone, and thank you all for joining us for today's webinar, the top 5 challenges in responding to participant behavior in family treatment courts and how to solve them. My name is William Moore, and I am with the National Training and Technical Assistance Center. And as your technical host, I would like to take a couple of minutes to discuss a few features of our Adobe Connect webinar platform. And I'd also like to make just a few announcements. Please note that this event is being recorded and will be placed on Intact's YouTube page. The webinar recording will be archived on Intact's YouTube channel, where you can also visit and view past webinars. For the event transcript and supporting materials, please contact the OJJDP PTA Help Desk. For those wishing to download a copy of the PowerPoint slides and other important documents, you may do so by locating the handouts pod directly above the chat area. Here, you will also find an FAQ for webinar participants that will likely address any technical related questions. Click on the file name and click on the download button. During today's webinar, presenters will address questions during our Q&A segment of the webinar. Please type your questions into the chat box as they arise. For those of you participating in today's webinar as a group, please take a minute to help us count. Go to the chat window and type in the total number of additional people that are in a room with you at this time. If you are viewing alone, there is no need to type anything at this time. And I'll give people just a couple of seconds. Please type in the total number of additional people joining you at this time. If you're viewing alone, there is no need to type anything at this time. Following today's webinar, attendees will receive a certificate of attendance. This certificate is sent approximately 1 hour following the conclusion of the event and is sent via an Adobe Connect thank you email. Please keep an eye on in your email for your certificate. Please note that only participants that are registered and signed in will receive a certificate of attendance. And note that at the conclusion of today's webinar, we will also provide an evaluation so that you all can provide feedback about today's presentation. I will now turn over our meeting to our moderator, Tessa Richter, for today's webinar. Thank you.
Thank you, William. Hello, everyone. My name is Tessa Richter, and I work with Children and Family Futures. We are an organization based in Southern California, and we work to improve outcomes for children and families affected by substance use, mental health, and trauma, especially those in the child welfare system or involved in the child welfare system. We are the TA providers for the National Family Treatment Court Training and Technical Assistance Program, which is sponsored by the Office of Juvenile Justice and Delinquency Prevention. So special thanks to them for their support. The opinions expressed today are those of the speakers and do not necessarily reflect those of the DOJ. So we're here today as part of our Family Treatment Court Learning Academy. Hopefully some of you joined us back in January, where we did a Learning Academy on Checklist to Change, and this really partners well with that. There's a short, about 30-minute pre-recorded video that's posted on our website that hopefully some of you have watched, but if not, it'll be great to watch with your team after this. It covers a lot of the basic tenets of this topic. As many of you have heard, we're very excited to announce that this summer, the National Family Treatment Court Best Practice Standards will be released. This was a publication with Children and Family Futures, with NADCP, and with leaders from across the country. A lot of the information that we're talking about today is from the standards and is based on the newest research and best practices. However, the standards aren't finished yet, and so we encourage you, if you will be at the NADCP All Rise conference this year, to come to the FTC session on the best practice standards, where they'll be finalized and released. It's very exciting. And we will also be having another separate session on response to behavior. So if you'll be at that conference, please come and get even more up-to-date information at that point. So if you haven't yet watched the video, put that on your to-do list with your team. It makes a great lunch and learn. In addition to this conversation and the video, we also have the Take Action Guide and the Team Discussion Guide, which are in the handout folder or the handout section on your screen that William mentioned. They give you and your team some great next steps and discussion points, a good process for next steps. So we're here today after the video hosting this live conversation with 3 panelists from Travis County, Texas. We'll introduce them in just a minute, but we have the judge of their program as well as respondent parent counsel, parent attorney, and one of the caseworkers. So the Parenting and Recovery program from Travis County, Texas started in 2008. It's based in Austin. They're an integrated model and serve both in-home and out-of-home families. We wanted to highlight this team because they've done a lot of trauma training and they really integrate trauma-informed principles as they work with families and respond to behavior. Also, all their team members are really involved in the process, and so that's why we were excited to have 3 different views from the same team talk about how they view responding to behavior. So with all of that, let's get started. We're actually going to start with a poll question. William, if you wouldn't mind putting that up. So please just let us know if you can select one. Which of these 5 challenges in responding to participant behavior is the most pressing for your team right now? So there's 5 options, or if you select other, please specify in the chat box what your biggest challenge is. All right, if you want to finish up answering if you haven't yet. All right. Well, it looks like we have a clear winner. 60% of the votes about taking an individualized approach yet still being fair. So we'll make sure our panelists answer some questions about that piece today. All right. So I'm going to move over to our panelists. We're going to ask our panelists to introduce themselves and answer this question. And I'm going to start with Judge Martinez-Jones. How, as the judge, do you see your unique role on the team when responding to behavior? Thank you for joining us today, Judge.
Well, thank you for having me. I'm very excited to take part in this. I am the judge that's presiding over our family drug court. I feel that I've had a little bit of an advantage because prior to being the judge, I was one of the defense attorneys representing the parents in this court. And from that perspective, and now as a judge, I realize that the relationship that the judge builds with each participant is really a key to success. And so my role really is to make sure that as I take all of the information from my team, who is very involved, I listen to everybody's perspective and all the information and insight that I can get from my different team members, especially during our staffings and what a response to a certain consequence or reward might be like for that specific participant. And I use that to really improve the relationship that I have with the participant from the bench, because I know that if I'm invested in them, they can tell, and they can tell if it's genuine. And I know that a lot of times the concern and worry about being a disappointment to me or really wanting to show me that they're able to accomplish something or are working hard is very meaningful and is another piece of our program that I think helps us become successful and not have to rely as much on certain sanctions. So I really look at my role of receiving as much information about the participants as I can, understanding them, their children's needs, their family, and then really building a relationship and building trust with them so that they will allow me to help them improve themselves and their families' lives.
Thank you so much, Judge. So now we're going to introduce Susana Castillo-Littlejohn. She represents parents in the FTC. Susana, can you answer that same question about your role when responding to behaviors?
Sure. So my name is Susana Castillo-Littlejohn. I'm one of 3 parent attorneys here in Travis County who represent the parents in our program. The way that I see my role is it's very complex. I have to make sure that I zealously advocate for my clients while at the same time, I'm protecting their constitutional rights, and I'm collaborative with everybody on the team. I think it's very important to have a very good working relationship with everyone that's making decisions about my clients' parental rights. So from my perspective, I encourage my clients to be open, to be honest, and to have good communications with, there's some noise in this room, I'm sorry about that, open communications with everybody on that team. I think what the judge said is very true. I think our program in particular is very unique in that we work very closely together, and all the decisions that we make in our group are very well thought out. But from my perspective, I have to make sure that while we're working together with everybody in that team, I still protect my clients' constitutional rights, and we're part of a lawsuit, so I always make sure that my clients understand consequences in certain things that they do and how that would affect long-term the result of the CPS case or the child welfare case in the situation. So, yes.
Thank you, Susana. And Susana, would you try to start your webcam again so everyone can see you when you're speaking?
I was wondering about that. I'm sorry. Let's see. Is that better?
Perfect.
Can you guys see me? Okay, thank you.
Yeah. All right, Jennifer, are you with us? I know we're having a little bit of issue.
I am. I can't see myself, so I don't know if you guys can see me or not.
Not quite, unfortunately, but we can hear you. So Jennifer Maddox is the child welfare worker with the team. Jennifer, can you answer the same question? How do you see your role as the caseworker in responding to behavior on your team?
Yes, I feel like my role in this position, we do work collaboratively. I think we work really well collaboratively. I'm kind of the first person to get all the info. I build a pretty good rapport with the family. I see them often. Not only am I seeing the participant, but I'm also interacting with the whole family to ensure child safety, which is my biggest thing. I also am looking at behaviors, making sure that we're seeing behavior changes because we also have a family plan that they are going by in addition to what the court is ordering. And so I think that as my role, I'm gathering all the information, current information in history so that everybody on the team can make a good decision about what is going to happen with the particular participant.
Wonderful. Thank you so much. All right, let's jump into our next question. So everyone will see in the new FTC best practice standards that all behavior responses should be therapeutic. So let's start with Judge Martinez. Can you share what that means to you and to your team, and how do you deliver responses in a way that's therapeutic and making sure that we're not punishing?
Sure. So our court has had the opportunity to have a trauma walkthrough. So we've all talked a lot about what does it mean to be a trauma-informed court. I always try and come to the bench with a perspective of keeping in mind what has happened to the person and not just what may be wrong with them. So whenever I'm working with parents and we're looking at the appropriate responses for whatever the behaviors may be, whether it's for encouragement or discouragement, I'm always trying to keep their personal history of trauma in mind and understand whether or not what I'm seeing is either something related to maybe their mental health, to their trauma history. to the substance use and the stage that they're at in their recovery, or if it's their will for noncompliance, because all of those things require a very different way in responding. We like to make sure that our parents, once they're in their inpatient program, that we give them some time to come off of any substances they may have been on when they started the program, and to get some stability before we go ahead and have them do a psychological evaluation. I use the psychological evaluation as a really big tool to help guide me to make sure I'm using appropriate responses with them whenever I am looking at whether there should be an incentive or a sanction. We try and also make sure that if there is a therapeutic need or another mental health need, that gets addressed as soon as possible, because we know a lot of times that can inhibit the progress that they can make. We try to be very mindful if some of our women have history that involves exploitation or trafficking, family violence, or anything else that could really make a big difference in any kind of response that I may give to some of the behaviors that we see and the compliance concerns that we may have. So those are all things that we take into consideration, and I give some time to get to know my participant a little bit more before we get into some of the sanctions that could potentially be problematic if I'm not aware of that history.
Thank you, Judge. Jennifer, are you still with us? I think we might be logging back in. Judge or Susanna, could you share a little bit? So what we're hearing is you guys really make sure to get to the why behind some of that behavior and problem solve how to support that why. How about if you feel like someone's being pretty dishonest, or maybe they're denying a positive UA? How are you? What conversations is your team having at that point, and how are you discussing responses?
Well, I'll talk about some examples that I try and use is thinking about the why again. I think that for the most part we understand that dishonesty sometimes comes from guilt or shame, and for fear about what the outcome might be if they are honest about, for example, having a lapse. And especially in our program where we're not removing the children from the parents at the beginning of our program, a lot of times the fear is that if they admit to use or they admit to a lapse, that I am then going to remove the child from their care. And so I've had situations where parents do not want to admit to a lapse, but everything in their behaviors looks like that may be what have happened. I try and employ a couple of things. One, I like to be honest with them. I tell them as long as they're honest with me, I'm going to be honest with them. And so then I'll tell them, I believe something is going on. I'm looking at your behaviors, and your behaviors don't look like somebody who's in recovery. And I may be wrong, but I'm telling you this is what I'm seeing, and it's a concern to me. And then I try and remove guilt, shame, and fear, and we'll let them know I understand that a lapse can be a part of recovery, and it's not something to be ashamed of. I usually also, when I'm talking to them, they're usually in my court, and I'll give them some kudos for that and say, you're still standing here in front of me showing up. So I know that you really want to do this, and I'm proud to see you there, and I respect you for even coming here. And then I'll let them know, it would be great if I could understand if you've had a lapse, how you've been able to get yourself back on track, or if you still need a little bit more help to do that. Because if we're able to do that in a way that's safe for your kids, I think we can work together to make sure that we're keeping your kids with you as best as possible, as long as we can make sure it's safe. So I try and let them understand what's going to happen or what could happen, my expectations of what I would like to see, and give them room to have made a mistake or to have had a lapse and be able to come forward with it without feeling the guilt or the shame. And I try and do that all within the context of, I pretty much know what's happened. I've been doing this for a little while, and this is how it looks, but I would love to hear from you what's going on with you, because there may be something I don't understand, and giving them that opportunity.
I know you started off talking about the relationship piece and how important that is, and we can hear in your responses that having that base is vital for how you're working with the families moving forward.
Yes, for sure, for sure. I don't know, Susanna, if you wanted to add anything to what I said about that.
I think from my perspective, it's really confidentiality going on, and sometimes my clients are very hesitant to not tell me anything because they don't trust that it would be.
Sorry, Susanna, can you get a little close to the speaker? It's a little hard to hear you.
Is that better?
Still a little hard. We could hear you better earlier.
I don't know what went wrong. Okay. I'm just gonna talk to you from the here. Can you hear me? Is that better?
That's great, thank you.
Okay, I'm sorry, I had my headphones, it was easier. What I was saying is that from my perspective, it's very hard when we're talking about honesty and encouraging clients to make that leap of faith and tell the judge what's going on, because we have the attorney-client confidentiality, so I always try to encourage them to be honest, because they have to be honest to be successful in the program. I think that it's tricky. A lot of people don't want to say that they made a mistake or they had a relapse. It's part of feeling guilty and scared. But in my experience, I try to build a really close relationship with them so that they can trust the advice I'm giving them. I try to ask why, when, how, if a relapse happened, because understanding what was going on then is going to give me a better, my ability is going to be better when I'm explaining what happened to the team. And a lot of times I encourage my clients to come up with a plan. So if something did happen, like a relapse, and it was when the kids were at daycare or something like that, I mean, what is going to be the plan going forward? And do we have an adequate caretaker that can have the kids while they get back on track? So usually it's helpful for me to have a plan to present to the team whenever there is a relapse or whenever a mistake has been made. And from my perspective, that helps my clients be honest, because they know that I'm their advocate and I've seen this before and I have a good idea on how we can make it work even when they had a relapse.
Thank you, Susanna. We've been hearing so much, and research is starting to show more just how important that advocacy role is and that support from the parent attorney. And so the messaging that you're giving to be honest and open and with the judge and the team is very important. Jennifer, can you hear me? Are you on?
I can hear you now.
Okay, great.
And I think my role in all of this is I feel like I have a very strong relationship not only with the participant, with the family, and my role is also to authorize a lot of the services like psychological and therapy and things like that. And so I think that I build a very good rapport. So a lot of times I'm the first one to hear that they've had a lapse, and I'm constantly discussing with the participants and my parents, what are we going to do if this happens, and who can the kids go to, and running background checks and making sure that the caregiver that of their choice is appropriate. And then again, it's just a lot of communication and empowering them and letting them know that it's okay, it's not okay, but we understand relapse is part of this process, and it's not automatically going to mean that I'm going to come and we're going to remove your kids. But having those conversations and making sure that they have a choice and empowering them to know that they're making a good choice to want to live the life of recovery. And it's always interesting to see when your parent makes that shift, and it's pretty powerful.
Thank you, Jennifer. So we got a question about when are you giving a response or a sanction? Is it for all problematic behaviors, such as missing a visit, missing a parenting class or a treatment session, or only relapses? Can you guys give your insight on that?
We do incentives as well as sanctions. And so if there's, for example, something that happens from time to time, like a missed drug test, we have community service if we don't think that it's related to an issue of noncompliance, but it's maybe a different behavior that we're wanting to discourage as far as keeping track of what they're supposed to be doing and calling into our system to see if it's their day to test. And so that is a sanction that they're pretty much aware if they miss a test and it's not necessarily a concern for us with the other behaviors that we're seeing, but there still needs to be a sanction for compliance. We'll assess community service. But what I often tell them is that if they want to do a recovery-related activity in lieu of that community service, that they have the opportunity to choose something that would be beneficial to the recovery community, and I will allow that to count as community service, because the ultimate concern, of course, with not doing a drug test is whether or not they may be slipping in their recovery, and we're not able to see that. So if I allow them to do something that gets them more involved in their recovery, then we definitely will allow that, because I think that is really getting to the heart of what we want. But we also give them rewards. We have awesome awards that we lay out on our table during staffing, and any team member who wants to just give a little note, a little certificate of something great that had happened for a participant, they fill it out and sign their name. And once I have their hearing, I hand them their awesome award, and they get to see that something they did was recognized. And it could be for any number of things. But we had a participant who always was losing her phone. And she finally went a week, and she didn't lose her phone. She kept it on her. We were all able to be in contact with her. She kind of got an awesome award for keeping up with her phone. So for anything, we could give them an incentive, and it's just a certificate that we fill out, and I get to hand it to them. But they really, really like to see when they get awesome awards, because they may get 1 or 3 or 5, and they really get excited when I hand them to them at the end of their hearing.
Anyone else want to add in on that piece?
I think one of the creative things that I guess our team came up with, I think it was you, Judge, but in doing community service, we've been able to fit that, I guess, sanction, if you will. We've had some of our participants observe our regular child welfare docket. We call them shared CPS dockets, where they are not in drug court. So we have also cases where it's just a regular, involvement of, child welfare, and the participant is not in drug court. And sometimes we have them observe that docket, one of our participants who needs to do community service, and just getting to see the difference in the approach, and how much help and how much resources and how much of the team is helping them in drug court versus if they were not part of this process, has been very helpful for some of my clients, and being appreciative, and just overall seeing the case in a different light. Like this is help for them, and everybody's trying to do everything they can to make sure they succeed. In our county, we don't have as much help, hands-on people in the regular CPS cases as we do in drug court. So it's a clear difference whenever someone's seeing another parent, having their kids removed or not getting, enough opportunities like we are in drug court, and that helps. And that's something very creative, I think, that we're using in our program here.
Thank you. So one thing I wanted to clarify when the question was about when do you give a response, is it for everything or just something? One thing you will see in the standards, and that's really important to note, is that parenting time should never be used as a response or a sanction. It's about safety and the best interest of the child, and it's a right for the child and the parent. And so I just wanted to clarify that piece, that should be separate from responses. Is that accurate for how you guys use parenting time in your program?
Yeah, we haven't ever had that be combined with an incentive or a sanction. Anytime we have to adjust the time with the parent, it is based on the safety and well-being of the child.
Yeah, that's what I've observed too. I mean, that's what we do.
Thank you. All right, we're going to move to a contentious topic next about jail. Before we jump into that, I did want to give a little bit of information. So we do know that the new best practice standards will say that jail is almost always inappropriate and counterproductive in a family treatment court. And there'll be more information in there, but about it's not being recommended in FTCs. These are civil procedures, and oftentimes jail will impact the ability to meet parenting time or dependency court requirements. There's some new research coming out about jail and FTCs. There was one study that showed, and obviously this is not causation, but there was one study that showed that when looking at a county that didn't use jail versus some that did, that the FTC that didn't use jail provided more treatment. They experienced faster reunification, higher rates of reunification, and children spent less time in out-of-home care. If an FTC is choosing to use jail, it's really important to look at the due process and have very specific guidelines. So with all of that said, we know that Travis County does use jail in some certain situations, and from hearing what you all do, we hear that you are using due process and using those very specific guidelines. So Judge, could we start with you and talk a little bit about how and why you use jail and what that looks like?
Sure. So we use jail, but not very often. I don't like putting people in jail. Whenever jail does become an option, we're going through the entire process because I don't take it lightly. So there's due process with a formal notice. I myself will type up a show cause for a contempt hearing, and it's for violation of a court order. I'm not putting somebody in jail for a lapse or a relapse. That's not what we're doing. It has to be that there was violation of a court order, and in a way in which I know that it's not related to their inability to actually be compliant. And here in Texas, that's an actual defense to breaking a court order, is that you were unable or incapable of complying with that order. So it wouldn't make any sense for me to try and use jail as a sanction for things that I think a parent would just be incapable of being compliant. So they get the notice, they have attorneys, all of our participants have attorneys to represent them, and I set that hearing as soon as I can, but with time, so that the parent has an opportunity to actually meet with their attorney and prepare their defense. And we have a formal evidentiary hearing. A lot of times the reasons why someone may get jail as a sanction is because of repeated times of noncompliance on some of the same issues. So for example, if they've missed not one drug test, not two drug tests, but three or more, and it seems that they're very blatantly not going to drug tests on purpose, and I have a concern. For not coming to court, that may be a reason why. And usually if they don't come to court, I don't issue a capias or a warrant for their failure to appear immediately. I'm giving them and their attorney an opportunity to first figure out what's going on, because my most immediate concern would be if they're okay, quite honestly. And so I will say, I'm going to be on the bench tomorrow or Monday. You can come to court and let me know that you're okay, and let's figure out what happened where you didn't make it to court. But that failure to appear is one of the other reasons why. And other things, I can't think of any other reasons except for the noncompliance with a specific order of not going to their treatment program. If they had treatment, they were supposed to go to treatment, and usually not the first time. If there's been one or two lapses and the plan is for them to go back into treatment and they have missed their entry date, I might set a hearing for contempt. But usually if they come to court saying, I'm ready to go right now, I'm not putting them in jail. I want them in treatment, and so I want them to go do that. And so making sure that they have the due process, making sure they know when it's going to be a possibility, they get a heads up. And I say, you know, if this continues, you may end up in jail, and I don't want that to happen. Let's see how things look over this next week before we get to that point. And I also take other extraordinary circumstances into consideration before I'll think about even considering putting somebody in jail. If they have the potential to be deported, for example, I'm not going to look at jail as a possibility. I just won't. If the child is going to have to go into foster care because of jail time, I'm not going to put them in jail. We plan for respite for the child, and we never do jail more than 5 days. We may do 2 or 3 days as the norm, but never more than that week time frame. We very much agree that it doesn't get better after that time. I usually have them tasked with something while they're there, as far as, you know, we're going to bring you back to court, and I want to hear about what you want to do moving forward. And if they have a plan about getting into treatment or making a change or doing something different, I'm ready to release them to implement their plan. And a lot of times, even if we go through a contempt hearing and I have counsel give me their defense and I hear the recommendations from the other parties on the case, most times I'll do a suspended sentence. So I'm not sending them to jail. The sentence will be suspended and they'll just have a criteria of things that they need to accomplish to get that removed and not implemented. And so it's very specific circumstances and not often used. And there also have been times where the participant will tell me, I probably should go to jail. I've had a participant say, I can't stop using. I don't have a safe place to be. I probably should be in jail. And I hate doing that too, but my good conscience, if that's the only tool I have to get them the treatment and in a safe place for the couple of days until we get them there, I may do that. But again, not for very long. If I know that they've come down while they're in jail, I will release them, even if we don't have the next treatment step planned, because that's never what I want to see long term.
Thank you, Judge. Susanna, can you give us your perspective on the use of jail as a parent counsel?
Yes. You know, nobody wants their client going to jail. And if I'm honest, I mean, I've been doing this for 5 years, the drug court, and probably I've had 2 or 3 clients in the long time that I've been in drug court go to jail. And it was for situations like Judge Martinez-Jones described. In all those cases, my clients knew this was coming. It wasn't a surprise to them, which I think is very effective. I mean, you have to, can you guys hear me?
Yes.
Yes. Very effective because you don't want to surprise them. You want to be trauma-informed, and you want to make sure they understand. It's tricky, I think, when you're going to have someone go to jail because, and this is part of our collaborative process, we talk about at staffing, about the person's history, where they come from. I just don't think that sending someone to jail that has been to jail for a long period of time in the past is as effective to someone that has never been to jail, or, you know, they were to jail one day and then they were released on bond or something like that. And these are some of the things that we talk about at staffing, to make sure that, is this really going to be an effective sanction? I mean, I know we don't like to do it, but in certain cases, yes, the situation merits that. But I think our court in particular is very good at making sure we know the client, making sure whether this is going to be an effective sanction, and we never, it never happens as a surprise. And it's true, we always get a hearing for a contested matter. I always meet with my clients if that's what they're facing. We come up with plans, we discuss the possibility, and then we have a plan in place to make sure that the child is not going to be put into foster care. It's not going to be a situation that's going to derail the client's success in the program, which I think we do a really good job in our court with making sure that's happening. And yes, I mean, it's unfortunate, but sometimes I think, I mean, I never say this to people because I have to advocate for my client, but sometimes that's the only way that someone can get back on track, I feel like. And I do remember in particular a situation with one of my clients. She was undocumented, and her behaviors were such that it probably rose to the level of having her go to jail, but because of her unique situation, our team came up with a different way to give a sanction to help her get back on track. And that's always taken into account, and it's something that I really appreciate about our court and representing parents. I like that things like that are considered when we're dealing with our clients.
Part of that trauma-informed approach, for sure.
Yes.
One question we're getting that we should have clarified at the beginning, is your program voluntary for families who are eligible, or are they mandated in?
It's voluntary. They actually get assigned one of our drug court attorneys to help advise them about whether this would be a good fit for them before they sign a contract agreeing to be in the program. But I will say, once they're in the program, it's not voluntary to get out. We don't make it so simple that they could just leave whenever they want. And so I know that sometimes they have that impression, but we let them understand what it means to come in, and that's why we make sure they have attorneys talk to them about it before they agree to come into the program.
Thank you. So our number one polling question was about being individualized but fair. Can Can we talk a little bit about how you tailor sanctions to be individualized, but make sure it still appears fair to others? I think we might have some questions, particularly when looking, you guys were talking about jail and certain circumstances you may not use that. But so how are you making sure that that appears fair to all the participants? Judge, I'll start with you. Sorry about that.
Okay, so y'all want to start with me. Again, I am looking at what's been specifically recommended for them, especially if it's something that's coming from a therapeutic approach. It may be that their psychological evaluation has some very specific things that we've got to keep in mind. And so we try and have a general outline of what typical sanctions, incentives may be, what our track looks like, and the things that need to be accomplished. So it's set out ahead of time what they need to complete each phase. And then within that framework, we try and make individualized plans so that we are best addressing their needs and their children's needs. Because we do work with their children very closely, we do have child and family therapists that are part of our team. We may get some recommendations there that look a little bit different. So we're constantly making sure that we keep their very specific needs in mind and use those as the differences while we also follow our structure and our program as everybody would have to complete to progress through the program.
And Judge, how about, one thing that we talk about a lot, and I think we'll see in the standards too, is that it's just as much about the delivery of the response as it is the response itself. Can you talk a little bit about that piece and how you deliver responses to families or to parents and how you explain it?
Sure, and I try and make sure that they also are able to see and they buy into the uniqueness of everybody's situation. And I also try and make sure that when I'm talking to them about what's very specific to them, that they understand that my goal is to think just about them and the time that we have together. So each hearing that I have, even though I'm going through multiple hearings each day, I want that special time for them to know this is about you, this is about your program, and your program is unique to you. I also try and make sure, especially if it's something like a sanction, that I remember any kind of response I may get or pushback that I might get or displeasure that they want to tell me in the sanction is not about me. They may have other things going on. If they're responding in a way that other people feel is very negative or even disrespectful, I maintain the integrity of the court, but I do not take it personally because I know there's usually something else going on that's stemming that response. And a lot of times I think maybe they're a little surprised with my calm response to maybe an over-the-top reaction, and I think just the difference in what they were expecting from me and what I really do surprises them, and they realize, oh, maybe I'm being inappropriate. And most of the times, if we've ever had that kind of situation, I've gotten an apology, even if I don't think it's necessary, but saying, oh, Judge, I think I was a little out of line. I apologize for that. I was just upset. But I think in even delivering bad news and giving them some understanding that this isn't because I want bad things for you or that I want to punish you or that I think you're a bad person. It's because I remember when you started this program and you told me what your goals were for recovery and for being a safe, happy, healthy parent, and I want to help you get there. And I think this is a piece of what's going to help us move together along to get you to where you want to be. And I think bringing that tone is very helpful in how they receive any kind of incentive and sanction that they may get.
I wish we could all see you in action, Judge. Sounds really great. Susanna and Jennifer, do you have anything to add on the individualized but fair piece?
I think from the perspective of the attorney having multiple clients and some of them seeing things that are being implemented differently to them, even though it's really not, it's just their perspective. Because whenever I advise a client at the beginning of the process, they get a binder with all the information about the spaces, the requirements, what are the possible sanctions, what are the possible rewards. So all my clients know the process and how sanctions are implemented and usually for what behavior. So from my perspective, whenever I have clients saying, well, she got something different than I did, or how come she's not going to have a contempt hearing, but I am, for me, it's very important to go back to the phases and the progress, because I think we do things, so that the expectations are different as they progress in our phases. Behaviors that, may not be so okay in phase 4 may be okay in early recovery. So those are some of the things that I try to tell my clients. It's individualized, and not everybody's the same. You're in phase 3 versus this person just barely got into treatment. I mean, she doesn't have as much sobriety. So I try to talk to my clients and make sure they understand that sometimes, even though it's all black and white in a binder, it's a little different because of where they are in the program or because of their situation. So again, communication, I think, is key when we're trying to make sure our participants feel like they're getting treated fairly and that this program is working for them.
You'll see in the standards, and the same in the adult drug court world, about proximal versus distal behaviors, which is really what you're talking about there. What might be doable and achievable for someone at the very beginning of the program is different than what's achievable for someone later in the program, and our expectations are different. So that definitely goes back to the explaining it piece, which sounds like they're probably hearing that from all of you, why they're getting certain responses, and that you're backing each other up, which is really great. We got a question about perceived fairness or favoritism. Do you guys ever deal with that, where a parent might, or where certain parents might think someone is being a favorite, or getting more incentives or fewer responses or lesser responses than others?
So I think that we as a team are pretty close, and so what I know happens sometimes is we notice, for example, one participant gets a lot of awesome awards, and maybe they have the kind of personality that people really enjoy. We like to check each other, and we'll check our biases. Is there a reason why we're not doing this for maybe this client who is maybe a little quieter, not as outgoing? So our team is good about checking biases. We try and call it out during our staff if we realize somebody hasn't been getting as much incentive as somebody else. And we really are checking each other and making sure that we encourage each other to be balanced and make sure everybody is feeling the support from the team on a regular basis.
Thank you. So I know I asked you all a few minutes ago about whether you're voluntary or not, and so there were some follow-up questions. Do you allow someone to opt out? What's the opt-out period look like? Questions around that. Can you guys respond to those?
I can if you want me to. So that's something that I go over very in depth whenever I'm advising my clients. I always tell them that this is a voluntary process. No one's forcing them to join drug court. But once they're in, they just can't change their mind. And it's actually part of a contract that they have to sign, understanding that once they're in, the only way that they're going to be released or discharged is if the judge says so. And it's after we all chime in and tell the court, or the service providers tell the court whether that's a good idea or not. So to me, there is no ambiguity whenever I am done advising a client and they sign a contract. They understand that there is no opt-out period. There is no, I just want to, leave. And the times that I've seen discharges from drug court has been because, there's consequences, right? If they just don't want to do treatment anymore, they just keep using, they're going to be discharged, and then they're still going to have to deal with the CPS case, and that's sort of like the consequence of leaving the program. And so they all know that going into the beginning stages of the program. So I think it's very clear to them, and I think it's effective. We invest so much time and effort in these cases, and it wouldn't make any sense if they could just change their mind after 30 days, right?
Sure. Yeah, one of the barriers. Go ahead.
Well, I was going to say just quickly that we do let them observe twice before they actually sign up. So they've seen the court at least 2 times, and that's our goal, before they actually sign to join the program.
Thank you. Yeah, I was going to say one of the barriers that we talk about, and that's addressed in the video, is when or if you should ever terminate a parent from FTC. So not necessarily that they want to get out, but that the team feels like it's time for them to leave. And so what we talk about in the video is that it should be close to impossible for a parent to terminate out of the FTC. Make it very difficult, and that the goal should really be on engaging and keeping parents in FTC. Do you guys have any policies or procedures around when a parent may be discharged when they're terminated from the FTC, and how often does that happen?
We do. A lot of times it's, again, a process like when we are doing a contempt hearing. I may set some special reviews to check in with them for, give them 2 weeks or give them 4 weeks and see if we see a difference, or if we as a team think that there's something else we can do to serve them. We make sure we're also checking our biases for the reasons that they should be discharged from the program, and that it's an objective reason and not subjective as far as based on something that wouldn't otherwise warrant them being terminated. And oftentimes I may have a hearing to see whether or not they should be discharged from the program. And I get all the perspectives, and I hear everybody's position before I make a decision. Not often do I just discharge somebody that day without them really knowing that it's coming, but it has happened. And when it's happened, it's because they have been unhealthy for the entire program. A couple of examples are somebody who is actively using and showing up to court that way and doesn't seem motivated to really participate in the program. Another example is a parent who we believe to be bringing substances to court and could have put everybody else at jeopardy. In those situations, I do have a hard line where I cannot have somebody who's going to jeopardize the other participants in the program, and those are the times that I have done it more quickly without going through a hearing or some review hearings before we make that final decision.
Thank you. So we know that the idea between sanctions and incentives and now what we call responding to behavior has changed a lot since FTCs have started back in the 90s. We started with pretty structured grids where if you missed 1 UA, you got 4 hours of community service, and if you missed 3 UAs, you went to jail for 4 days. And we've really shifted away a lot from that, obviously. So now we're talking about more individualized approaches, and that any response should be therapeutic and trauma-informed. So can you all talk about what that's looked like for you? What has that change and shift in your team's approach been over the course of your FTC? I think we're going to start with Susanna there.
Are you talking about the non-compliant behaviors? Is that the one you're talking about? I'm sorry. I
about
you very well.
I'm sorry. About your team's shift in approach and responding to behaviors.
Right. So it's just individual. I think it just depends on each participant. When we sit down, we really talk about what would help that particular participant get back on track, I think. I don't know. I think I misunderstood your question. I'm sorry about that.
Well, that's okay. We're just talking about how responding to behavior has really changed. And I think you guys were going to give some examples or stories of how your approach has changed.
And I'll just jump in real quick as far as the longevity of our program. We really have moved more towards trauma-focused support. When we got started also, we were looking at the trauma just around the removal of a child. And that's when we decided to make a change and have a primary program where the children remain with their parents. So that was one of the biggest shifts that we've had, was to provide more supports and services to keep the children in the home rather than doing the removal. And then also improving the therapeutic services that we provide. So before we didn't have a child and family therapist on our team, and now we have 2 to assist the families. We also are providing EMDR therapy to all of our participants as well, and really just making sure that we're tying together what the program is really about, which is parenting in recovery, and that the parenting and the recovery are the 2 heaviest pieces. One of the other shifts that we had was we've started to make for graduation a graduation project so that they give back to the program. and it's whatever they decide to choose. But in that final phase, they're working diligently on how they're going to leave their legacy in the program and how they're going to be a part of it and contribute to it. Because we are working on having a greater alumni program for our court, and that's really been a key piece to getting more, I guess, buy-in and commitment and feeling really part of something is having those graduation projects and presenting that. And I think we've seen a lot of really good successes, which I think Susanna and Jennifer are going to talk about some of how those things and those shifts have helped us see really great outcomes.
Yes, that's right. And I'm sorry about that. So I think our program does very, very well in dealing with applying different types of styles and helping a client. We had a client recently, it was actually my client, who initially when she came into the program, she wouldn't really communicate much with anybody. She had so much trauma that had happened to her. A couple of her family members had been, they killed themselves, and she was in the foster care system. I mean, just one of the cases that, the worst cases I've seen when someone experienced trauma themselves to the point that she didn't even know what she needed to get better. I mean, we knew part of the problem was substance abuse, but she was one that had multiple other issues, mental health, just the trauma. And our team was very good in trying different approaches to help her. At the beginning, obviously, she did the inpatient treatment and the IOP, but that was not enough. She was very guarded. I talked to her. I mean, it was 24/7. Whenever she wanted to talk to me, I was trying to build that trust with her. And eventually, it took, what about like 9-10 months into the program, I'd say, she opened up and she said she finally wanted to do therapy. And this is something that we had all been trying to tell her about, therapy in different ways, from the family therapist, from the caseworker, from even the judge, I think, might have mentioned it. I mentioned it a lot, and it wasn't working for her. So I think that that's how our team is an example of how they shift in trying to use different ways to help a participant. And for my client, once she, and it was almost like it was her idea that she wanted therapy, because she wasn't listening to anybody. But once she said that and she started to do EMDR therapy, it was a big shift. It was a big change. She was smiling, she was more receptive, and she really, I think, turned the corner. I mean, she graduated from our program, and if you were at that graduation, every single service provider that had something to say to congratulate her was holding back tears. It was very emotional because we felt like it was a group success. It was amazing. Yeah.
Jennifer,
I have to agree with Susanna. Yeah, I have to agree with Susanna. She's probably, to this day, the hardest parent that I have had to work with. She resisted at every step of the way. She ended up having a relapse, and I picked her up, and it was in that moment that I felt like there was a trust that was built between us. And I think that with a lot of these parents, that's the goal, is you have to build that trust with them. And I, over and over, tried to relate. I tried to bring in personal experiences with myself. I think a lot of them, CPS is not their favorite people, and so I try to relate to them to, I'm a person just like you are. I could be in your shoes. I could have made one wrong choice, and so I try to really relate. And there was just an overall, when therapy was her idea, it was a huge change, not just in her attitude, but her perspective on life. She was planning. She was wanting to move out of the county, and she had this elaborate plan, something that I didn't even know she was capable of doing. Her parenting, she was nurturing. She took on a totally different parenting role than we had seen. And she's actually reached out to me several times after graduation, thanking me and just saying that she's still sober, and just updating me on her life. And it's, I don't know that I will ever forget the experience that I had with her.
And I wanted to mention about this particular participant because it really brought to light, I think, for a lot of us, how extensive trauma can be for people She was somebody who experienced trauma as a child. She wasn't raised by her parents. She experienced trauma through death in her family, and really a lot of things that made it difficult to even have her in the courtroom because she was triggered by so many different things. And I remember early on in the program, you know, as I was building a relationship with her, and I saw so much hurt in her and that she was broken, but she was really there to try and do something different. I had told her from the bench that I hope that this works for her, and I hope that she will accept our support because I cared about her. And I was very surprised at the response that I got. She was angry. She was angry, and she did not accept that I cared about her. She was mad that I said that. And I remember she said right back to me, she said, "You don't even know me. How can you care about me?" And I was caught off guard, but I understood what was going on with her. And I said, you know what? That's okay. You don't have to accept it. It's how I feel, but I hope someday you are able to accept it because it is genuinely how I feel. And through moving forward and step by step, and she saw how I responded to her when she was having trauma responses and being triggered in court, and it wasn't, I think, what she expected. And when she did decide that therapy was her idea now and she was going to do it, we saw a difference in her. We saw a change. We saw what EMDR therapy can do for a person who suffers from extreme PTSD. And when she was graduating, she came up to me and she said, "Judge, you remember when I was mean to you when you told me that you cared about me?" And she said, "I understood what you said." And she said, I love you, Judge, and I love me. And then I told her I love her too. And it was just amazing to see her get from that place where she couldn't even accept somebody else caring about her to where she was saying that she loved herself and that she was loving other people. So it's really important work keeping the trauma as a big piece of what we do, because most of our parents really, really are struggling with getting through that trauma in order to get to a better place in their life.
That's definitely what I was going to say. All three of you talking about that mother, very obvious about the trauma-informed approach and how that assisted her in moving along and your support of her. So that's really great. All right, so we're going to move a little more to audience or to the participant questions. One I wanted to address right away. There was a couple questions about involuntary or mandatory admission into FTCs. And Travis County does not do that, but there are FTCs across the country that do a mandatory admission into FTCs. And it looks different kind of wherever you are. There's some counties where if you have an open child welfare case and you have a substance use diagnosis, you are automatically entered into the FTC. Others will put you on the docket, and it's kind of, you know, if 2, 3, 4 weeks into it you're not engaged in treatment, then you enter into the FTC even if you didn't want to. I believe there's a study, there's a paper, I think it's from the University of Kansas, but Russ, if you want to correct me on that one, that we could share with anyone who's interested about the mandatory approach. So it is something that's out there. Travis County does not do that, but that is an approach that some FTCs decide to take in some counties. Sorry, I'll look through these questions a little bit. One question, could you guys give an example of what a graduation project looks like?
We do. Some of my clients have been very creative in their projects. One of my clients, probably couple of years ago, she came up with her own meeting for, you know, AANA, and the name of it I thought was very creative. She was one of the younger participants, like early 20s, so, you know, she always felt like whenever she went to AANA meetings, most of the people that were older, and she didn't really feel like she could connect with them, so she made her own meeting, and she told us about it at the graduation, and I think it's still going strong. It's called The Young and the Restless. And so I thought that was very creative. And that's just one example. A lot of clients want to do their personal story, or in the particular client that we were telling you about in her project, she spoke about how rehab had in fact helped her graduate and had helped her be a stronger person. So it was basically how relapse helped her get through drug court in a way. And so it just varies, but I think our participants are very creative when it comes to their projects.
Were they,
I know
they their projects and kind of present it to be approved? Is that how that works? Are there any guidelines around it?
It's something that has to be presented prior to graduation. So the way that it works is something that we are sort of aware when they're at phase 4, what they're working on, and then the day that they're going to graduate, we have a staffing, and we talk to them, and they present it to us, and, you know, we ask them questions, and then that's something that is presented at their ceremony, at the graduation ceremony.
Awesome. So I was corrected. The mandatory enrollment was from Lancaster, Nebraska, not Kansas. I'll claim to be close at least, but we did just put up the citation and link to that in the chat box. So if you're interested in that, please look into that. So let's see. So this is slightly related to response behavior, but I think it's a really important question. And because, Susanna, you are so involved and supportive of the FTC, I think it's a great time to talk about it. There was a question about how to incentivize parent attorneys into being a part of the FTC and kind of taking this approach of that it's a good thing. So can you speak a little bit to why you see this being your role as a respondent parent counsel to support parents, to get them involved in the FTC and to support recovery and reunification that way?
Sure. So I started doing CPS child welfare cases around 2006, 2007. I think that was prior to the drug court program starting, and I just kept seeing that a parent could do their services. They could, you know, try the best they could, but without the support and an effective program to maintain sobriety, it was hopeless. I mean, they would relapse in 7-8 months into the case, and I would be facing a termination trial. It was very exhausting, and I felt like there's got to be a better way to do this. And then I heard about Travis County coming up with the drug court program, and I immediately, I mean, whenever a position was open, I applied because I felt like if you are going to represent parents, you want to make sure they have all the tools they need to be successful. I wanted to make a change, and I wanted those parents to feel like someone was really looking out for them and that they were getting the help they needed to be back on track and actually have a really good foundation, because we all know relapse is part of recovery, and what's important is what you do during a relapse, right? If you have a good foundation, a plan, you have a safety net of people that you can turn to for help, you have made a good community of sober people that can help you when you're feeling like you're about to, you're not in a good place, you might be relapsing. I mean, that's what we want to teach our participants, you know. Yes, we want you not to relapse, but if it does happen, do it in a way that's safe, in a way that your kids are not going to be harmed, and you won't have another CPS case. So when I started, you know, learning about the program, I just wanted to be part of it, and the minute there was a position open, I applied for that.
Wonderful. Judge, do you have any thoughts on that piece, on how maybe to encourage respondent parent counsel to be involved in reunification efforts like this?
Well, I think we're lucky in our county. Our attorneys are very supportive of this. I think they wish more people could do the program. Of course, we don't have the resources to expand beyond what we are. I think we're one of the largest family drug treatment courts in our state, though. I think we're maybe around 40 participants, a little bit more than that. And you know, I wish we could expand it and have it be the case as norm. But what I've seen happen is, because we do have this program and we have people who from our jurisdiction also working on the other cases that are not in the drug court, that what we do and the expertise that we're honing here does move into the other docket. So all of the cases in our jurisdiction really are seeing benefit from having the program, because all the extra education that we do, we usually open up to all of the attorneys, and once they're able to get more information and able to be more involved, they have been very supportive of the program being here. We do only have room for 3 attorneys to represent parents right now in our court. As we grow, that may change in the future, but that's what we have right now. But those attorneys, I know when I used to be an attorney, would also answer calls from colleagues who may have questions about their cases that are not in drug court but require a little bit more expertise. And so we're really sharing our knowledge and benefiting the whole jurisdiction. And I think that with that, we've seen some support from a lot of the other attorneys as well.
That's great. That's what we like to say, being a part of change instead of apart from change, and using the FTC to really impact systemic change in the county. So that's really great. We know another piece is data, right? I mean, if you can show in the FTC that kids are going home sooner and more likely to go home, maybe that they get more parenting time, those are all, I would assume, Susanna, music to a parent attorney's ears, right?
Right. Can you repeat the question? For some reason, you're not coming across very clear. I'm sorry.
Oh, I'm sorry. I was just saying that data to show that that kids are going home sooner or are more likely to reunify is important for a parent to hear.
It's very important. And in our program, like the judge mentioned, we our participants get to stay with the parent. We call that a court order services case. So when we're able to close that case right at the 1-year deadline, it's, you know, for them it's the world. In our court order services cases, we could do it longer, but obviously whenever, you know, you get to close out the case early, it's very exciting for me and for my clients.
So we got a question about incentives, and I think that's actually funny that we haven't talked too much about incentives yet. We've kind of focused on the sanctioning piece, but we know that incentives are super important, very powerful, and a big piece of responding to behavior and shaping behavior. Jennifer, can you talk a little bit about what incentives you all use, and maybe some of the more unique ones that support the family?
So I think our biggest thing is the fishbowl, and the girls and the men are always excited when their name gets called. I think some other incentives that could or could not be called an incentive is the department has a partnership that we're able to provide a lot of like essential needs, like if they need diapers and wipes and things like that. And then the awesome awards are always a good way to incentivize the good things that they're doing. I'm trying to think I know that those are the 2 main incentives that we use, is the fishbowl.
And I would mention another that our parents seem to like. One of our managers will talk to them, especially as we get new groups of parents involved, about the transition to how to dress and how to care for yourself and how to feel good about yourself. And so one of our case managers would give them presentations and give them tips, and then we assist them if they need new clothes or more clothes or different sizes usually is what happens. And then after she's given them this, I guess it's just like a little case management session, and she does with our group every once in a while, I'd say maybe every other month or something like that, our case manager who's in charge of assisting them with that does a best dress, and it's a tiara. And it's not one that they keep and take home, it's one that we keep with our program, but she will pick out for the day who is best dressed, and she'll let them wear the tiara during the docket, and then at the end they take a picture with me, and then they get the picture. And they really seem to love that as well, and I think it's a way to encourage them to improve themselves in all kinds of capacities. We also will do a lot of things that may be related to their health. We'll assist them. I know we talked about, we've had our alumni take them to the farmer's market so that they could use their food stamps there, and they learn how to maximize that. And so those are some things that we do. I usually give them, some kind of extra kudos when they come to court if they were able to do something like that to help themselves and help their family.
That's a lot of low or no cost ideas, so I love that. And it just shows that you guys are having fun with it too, which is super important. I think go ahead.
I think the judge, one of my clients really liked is when the judge had this little points that if the clients were early to the docket, she would give them this point as a reward, and then they could leave after their hearing was held at a future time. And they felt like that was special because they could go and take care of whatever they needed to do that day, and they really liked that reward.
There's some great incentive ideas coming to the chat box too, so thank you all for adding those. And then there's some additional incentive ideas in the video too, the pre-recorded video. All right, so we're finishing up, coming to the end of our time. I would love if we could finish up, if you guys could all give one piece of advice, just, you know, your one nugget when thinking about responding to behavior and helping shape behavior for families. So Jennifer, let's start with you. Oh, if you're talking, you're on mute, I think.
I think the biggest thing is being honest, and then also making sure that the parents know what the behavior outcome or what the behavior needs to look at. I know from like CPS perspective, I'm looking at behaviors all the time and if they're changing, but I also want to make sure that the parent knows what the expectation is when it comes to those behaviors, and being honest and making sure that they know throughout their time in the program that, hey, we could work on this a little bit. And I think the biggest thing is just making sure that that is being communicated.
Thank you. Susanna?
From me, from the perspective of an attorney representing parents, I think the way that I have been able to help my clients respond to behaviors or change their behaviors, behavior modification, is by having a very open communication with them and having them trust me and the advice that I'm giving them. I think that, for me at least, that has been very effective. If my client knows that I'm telling them things to help them succeed, they're more likely to listen to my advice. And my advice at that table, I mean, what I'm doing at that table every day we're staffing is trying to get the team to see where my client's coming from. And for me to be able to know my client that closely, it requires communication, it requires trust, it requires a level of interaction that sometimes it doesn't happen on regular cases. So that's the biggest advice I have. If another attorney is representing parents, they have got to know these people like they're their family, because at that table, at staffing, you have got to give that perspective and where they're coming from, and your client has to trust when you tell them, you know, you have got to go to do this IOP. This is good for you because it's particular to your situation. They have got to know that you know them very well and that you trust them and they trust you, and together you are a good team.
Thank you. Judge, can we finish up with you?
Sure. I would say when we're giving incentives and sanctions, I'm constantly thinking in my head the ultimate goal. The ultimate goal is really breaking a cycle. Sometimes it's hard to give out a sanction, and sometimes you're hoping the incentive is really hitting home and getting us to the encouragement that we want to get those parents in a healthy, safe, stable place. And so I always am keeping that thought, that feeling, that desire to really make a change now to break the cycle that may occur in the future, because that's how we're going to be making a long-term impression on this family and improving our community.
Wonderful. Well, thank you so much to Judge Martinez-Jones, Jennifer, and Susanna for your perspective and for your great work in Travis County for families. Thank you all to our participants for joining us, for all your ideas, all your chatting and suggestions and questions. You've had some really great questions. I saw some pretty tough questions around domestic violence and housing, alumni programs. So just know that the ones that we'll get back to those. We'll put some additional questions to our panelists in writing and get some responses to those. We also will have all these materials and this webinar recorded. It'll all be posted on our Learning Academy website, along with the discussion guide and take action guide, which again are in the handout pane. So please download those. If you're coming to NADCP All Rise this year, please come to our sessions. We'll have, I think, about 8 to 10 sessions in the Children and Families program. Super excited about the release of the standards. If you won't be there, know that the FTC standards will be posted online and released, so please check those out. If you have any questions for us, please email us at fdc@cffutures.org if you have any questions about this, want to get in touch with the panelists, or just have some TA questions about family treatment courts in general. So thank you so much for your time, and I'll turn it back over to William.
Great. Thank you again to our panelists and our presenters. And just a few last-minute announcements that I have for everyone before we adjourn. Please be sure to join us for our next FTC Café Conversation, Fostering Hope and Healing, Role of Resource Parents in Supporting Family Recovery and Family Reunification in Family Treatment Courts. Sorry, that was a mouthful there. It will occur on May 23rd, 2019. From 2 to 3:30 p.m. Eastern Time. So we look for some of you all to join us for that upcoming webinar. And you may also contact INTACT through the website that's displayed on this slide. You can stay up to date on the latest information by signing up for INTACT's TTA listserv. Also, don't forget to check us out on Facebook. You can also contact OJJDP via the help desk. Oh, I'm sorry.
I just have one more announcement I didn't want to forget. OJJDP just released the FTC solicitation for grants for 2019, so please check that out. It's due at the end of May, so you have 2 months. It's for existing FTCs for enhancement grants and for implementation FTCs and planning, and a new track for FTCs serving veterans. So very exciting. Sorry to interrupt, William. I just wanted to make sure to announce that.
Yeah, no worries. I think we'll be hosting that webinar as well, because I'll need to check my records. But thank you for that announcement too. And again, just to let everyone know that if you want to contact OJJDP, then you can reach out to the help desk by following the contact information on this slide. Again, the slides are located in the handouts document as well, and includes all this important information. Do you have a TTA need or a request of some sort? Then please submit your request through OJJDP's TTA 360 platform through the link displayed on this slide for any TTA request that you may have. As a reminder to everyone, the webinar is being recorded and will be archived on INTACT's YouTube channel, where you can also view past webinars. And for the event transcript or even any other supporting materials, please contact the OJJDP TTA help desk. Please, everyone, take a few seconds to read the disclaimer here. And lastly, we would appreciate if you all would take about 5 minutes to complete the feedback evaluation. Again, thank you all for joining us today. Have a great afternoon. Goodbye.